Good afternoon. Our first case of the afternoon is in re Lange. You both have 15 minutes for argument. You may waive your free fire zone, and you may reserve time for rebuttal, but we ask that you keep track of it yourself.
Thank you. Timothy Pinto from University of Michigan Child Welfare Appellate Clinic on behalf of Kathleen Lange, appellant mother. I just want to point out a couple areas that there's a lot of agreement in this case. There's agreement that it was unsafe for the child to return home, that Ms. Lange made extraordinary efforts to help him as a parent, and that the solution for this child was residential treatment facilitated by DHHS. We disagree on whether jurisdiction was even necessary in order for DHHS to provide that help, but we agree that if jurisdiction is pursued, there's a way to do that. The dispute is, how do you do that, whether it's B1 and B2 under 712A.2 or B3. The difference matters a lot to Ms. Lange. I'm not sure why it matters to DHHS, but it matters a lot to Ms. Lange because under B1 and B2, there's a requirement that you find that she's unfit, that she's failed in some way, and that starts the process that could ultimately potentially lead to termination of parental rights. Under B3, there's no such need for a finding, and I'm happy to waive the rest of my free fire zone and answer questions.
Counsel, I would love to just know, where's the child now?
The child now is in foster care because as soon as jurisdiction was ruled no, they opened up a new case under B1 and B2, and they put it on hold while this case is resolved.
Okay.
I'm sorry, say that again.
So they just filed a new petition the very next day using B1 and B2, and the trial court said, we're just going to proceed that way, and the child was put in residential treatment.
Okay, so, and I'm just I want to make sure I procedurally have a handle on this. So if we agree with your arguments, let's just assume we agree that this neglect is not a good fit for this case, and perhaps a different section is a better fit. If we were to agree with you and say, nope, don't have jurisdiction under that, is there now a lack of jurisdiction, and what happens to the child?
Yeah, so if you agree that there's no jurisdiction under B1 and B2, then a couple things can happen. As we've argued, we think that DHHS can still provide assistance. For one thing, this is a child that is adopted, and so we pointed out in our brief that there's funds set aside. But even if DHHS says we need jurisdiction, they would just have to file a petition under B3. This is just a little bit of a weird case in which the interests are aligned between the parent and DHHS. They both agree that this child needs help.
Have you gotten any indication that, because you said that they refiled under B1 and B2, but not under B3. So they were just following the Court of Appeals. The Court of Appeals said there's jurisdiction under B1 and B2, so they filed that, but nothing under B3.
So they didn't wait for the Court of Appeals decision at all. It was literally the day after the trial court said, no, we don't have jurisdiction, and it went up to be appealed. While it was being appealed to the Court of Appeals, DHHS said, well, we still need to proceed. We still think we need jurisdiction. They refiled the petition.
Okay. So every indication that you've received from DHHS is that they want jurisdiction over the child to assist the child.
Correct, and that they only want to proceed under B1 and B2, and their briefing...
That they only want to?
Their briefing suggests they don't believe that B3 is appropriate.
Right, okay.
Yeah. And I also want to emphasize, I don't think that there's much dispute about the underlying facts, but to the extent that you're arguing neglect has occurred, there has to be some point to some action or inaction on behalf of the parent, and there's nothing that they can point to. The trial court said, nobody has told me what the mother was supposed to do. The lawyer guardian ad litem agrees with us, that has supported our side and has said, if she had tried to take this child home from the hospital, that would have been neglect. So it cannot be that she committed neglect by not bringing him home when that very act would have been neglectful.
Counsel, if we were to think that B3 could apply in this circumstance, would we have to remand for a determination? I mean, the petition obviously wasn't filed under B3, so is that something that we can just decide, or do we need to remand for the lower court to sort of hash that out?
I think a remand would be necessary, but obviously I'm asking that you affirmatively indicate that B3 is appropriate so that there's no uncertainty on that end.
Thank you.
Yeah. There's been a lot of talk the briefing and in the dissent to the In re Holbrook. In re Holbrook was a case that ended up being found moot, but Justice Kavanaugh, you had a dissent in there. There's been a lot of talk about we need to refine the statute. We certainly would support fixing the statute, but I want to make it clear that our argument is that there's no actual need to do that B3 provides that avenue right now. And of course, statutes, it's always nice to clarify, and we'd support that, but it doesn't.
So I will ask your opposing counsel as well, but I'd like your your theory or your thoughts about why is it that if there's agreement and a desire to exercise jurisdiction over this child to be able to get him the services he needs, why does the department, why do they not want it under sub 3?
I don't know. We've actually.
Well, I mean, is there some consequence that perhaps we're not thinking of to finding that he's homeless? I mean, a finding of jurisdiction under sub 3, I mean, that could be a basis that could eventually lead to termination as well, right? I mean, it's.
So we would argue that B3 cannot lead to termination.
It cannot.
No, that's Sanders really, is that until you find that a parent is unfit.
Is unfit.
You can't proceed. And, my best guess is that this is a little bit of a new way of proceeding, and it's not an entirely developed area of the law because we've never pursued, there's not cases out there too often where they've redefined how broadly we can read B3. I think, as we've laid out in our brief, it's very appropriate to do that. And there'd be some questions on the margins about, so if you you treat the parent like a non-respondent, essentially, just like in Sanders, where there's not a finding that the parent is unfit.
Would a parent be entitled to services upon a finding of jurisdiction under 3?
I think DHHS has wide power to suggest services, but I don't think they could require the parent to participate in services.
Because there hasn't been a finding
of unfitness. And I think actually that's the crucial difference. And as soon as they got to the point where they feel the parent needs to be required to do something, now I think you're in a world in which you think the parent has failed to do something, is neglected or failed or refused in some way, and then B1 and B2 becomes more appropriate.
Well, what about the concern, and I recognize it's not the facts of this case, I don't think by anybody can really argue that, is that by the concern that a parent might create the situation of homelessness in order to create jurisdiction over a child that they either don't want or can't provide for, and they want the state to take it. Is that a realistic concern? Not here. I'm not suggesting that the record suggests that this mother did anything.
I would take the
close to
position.
that.
I would take the position that if the parent has created the homelessness through some act or inact that you could just describe as neglectful or negligent, then we are back in the world of
Then you
B1 and
wouldn't
B2.
be in 3 anyway.
Yeah, and I think that's actually what makes this case a little bit unique and why it's so concerning. Just to remind you, this is a parent who decided to adopt a child with special needs, and there could be a real chilling effect on other parents' decisions to do that if they're going to be branded as somehow it's a quasi-criminal accusation that they've done something wrong.
So one more. So you mentioned here that there, in this particular case, because of the fact that the child was adopted, there wasn't a need, or it didn't require the court to take jurisdiction over the child for the department to be involved and provide services and help to this kid, right? Because of the department is involved in providing that for adoptive children. But a non-adopted child, and we've had that in other cases, right? Like that is there an ability for the department to become involved and provide assistance and support and help short of taking jurisdiction?
They do it all the time. So I was just looking this morning, MCL 722.628D lays out all the different kinds of cases and how you categorize them. And it goes from everything from we've looked at it and there's nothing to do here, we're not worried in any way, all the way up to level 2. Category 2 is child protective services are required. We're still not at category 1 where we file a petition. And category 2 says the department must open a protective services case and provide the services necessary under this act. Honestly, and this is where I'm not enough of an expert to answer, but because I'm not on the DHHS side, I think some of this is a funding issue, is that once they can actually put the child in foster care, they're able to tab federal funds. And so when they say we must have jurisdiction, I think what they mean is we need it because otherwise we won't have the money.
Trigger forwarding funding.
Yes.
Okay.
So if there are no further questions.
Well, help me understand your argument that the juvenile was homeless, right? That's what you're focused on, is that right?
So in this case, the mother was not homeless.
Correct, there was a home. The mother, if I understand the facts correctly, on July 8th, the treatment facility determined the child was non-dischargeable. But on July 9th, the treatment facility determined that the child was dischargeable with outpatient treatment.
Correct.
And the mother disagreed with that.
Correct.
So that renders the child homeless under your argument? So I'm just trying to understand you come to the Supreme Court, we have to make rulings that are generally applicable across the entire state to all litigants. So is it any time that a parent disagrees with a treatment provider, the child becomes homeless?
No, I don't want to be misunderstood as arguing that we are now giving parents license to just say, I disagree with the hospital.
Where do we draw the line, and how do we
Where
draw
the
the
trial,
line?
where the trial court makes a finding that the hospital was wrong and that it's not safe for that child to return home, and the trial court specifically says there is nothing this
But
parent.
that doesn't happen until after the parent has decided to not bring them home. So the challenge has to come first, and then.
Right, at the jurisdictional question, when you raise a jurisdictional question in front of the trial court, I think the trial court has to be the final say, make a factual finding about whether it is correct or not that the parent is unable to bring the child home, which is B1, or whether the child is homeless, which is there's no adequate home for this child. It's a factual finding, and it's very clear that this trial court made those findings here. But Justice Viviano, I completely agree that it shouldn't be the case that a parent simply needs to say, I disagree with that doctor, and now we somehow have triggered a jurisdictional mechanism. That can't be
What
the
did
case.
the trial judge base his ruling on, disagreeing with the medical professionals? Was there a contrary medical opinion?
No.
Expert opinion?
No, the trial court simply noted all the evidence about how difficult it was to care for this child, all the different attempts to provide care for this child, both by the mother and in another care facility. And on the Court of Appeals even noted, it seems like the hospital simply decided to wash their hands of this child. It wasn't a finding.
And I certainly don't mean to make light of this case, the difficulties involved in this situation and the efforts that the mother made. But I'm just trying to understand, what legal principles are involved here. So the child was, I think under your theory, at most temporarily homeless? Is that right?
I think that's right.
So you're asking us to recognize a category of temporary homelessness?
I'm asking this court to, where the trial court makes a finding that there's no adequate home, to recognize that that means that the child is therefore homeless. And
But there was an adequate home. The problem was the child needed care, treatment, before he could safely, if we go along with the trial court's finding, before he could safely reside there? There was an adequate home. It wasn't that there wasn't a place of shelter for this child. It's just the child in this current condition couldn't be placed there?
I think we disagree about what adequate means. If that home is not.
I'm not trying to be controversial. Explain to me what I got wrong there.
Just that is not a home that for that child is going to be proper care. It would be neglectful for her to bring him home because of the risk he himself faces, because of and also the risk that his siblings would face. So it's not adequate for him.
So if somebody needed physical therapy before they could return home, they would be homeless during the time when they needed inpatient physical therapy?
If it would be dangerous for that child to be home before they get that physical therapy, then I think yes.
Okay.
It's determined at the time of the petition.
Correct.
Correct? So the
Right.
fact that perhaps through services or other things, you might be able to remedy the situation or improve it or what have you, where he may, at some point, hopefully, right? I mean, this is the goal of everybody here, is to provide care for this kid to hopefully get to a point where he can safely live with the mother who wants him to live with him.
I think, as I said at the
siblings.
beginning, I think there's a lot of agreement here that's what everybody wants, and there's agreement about what that plan should be, and we're just trying to figure out the jurisdictional trigger.
So that jurisdiction is at the time of the filing of the petition.
Correct.
Okay.
But there can't be, we can't find a bright line rule here, because, I mean, it's kind of specific to this situation. We could have a parent that says, no, you know, the child can come home. I do think that we can create a safety net where they are safe. And it could be the exact same facts and very similar facts and situation. So it's going to have to be on a case-by-case basis. It can't be that it's just as Viviana was asking, where, you know, it's, you know, someone that is being, you know, discharged or needs services, that it's automatic that there's a finding that they wouldn't be safe at home.
The only bright light rule is that I do think exists is once the trial court has made a finding, either under, so B1 would be a question, is the parent able? And B3 is there a home that's adequate? But those are just easy factual not easy.
But it's kind of unique though, because usually when we're looking at the court taking jurisdiction, it's not the parent that gets to decide. Right? I mean, so that's kind of unique here, where it's one parent could say, nope, child can come home, and another similarly situated parent can say, no, I can't do it.
I know my time's up, but I'll
Yeah.
just quickly respond. I don't mean to suggest the parent gets to decide.
Not decide, but they get to start the conversation.
If this parent tried to bring this child home and someone wanted to accuse this parent of committing neglect because it's clearly unsafe for that child to go home, then I think you have a B1 or B2 jurisdiction.
Well,
Even if the medical professional says the child's dischargeable to the home, you think the parent wouldn't be able to stand on the advice of the medical professional? The parent's supposed to overrule that advice?
It's absolutely relevant that the medical professional said this child can be released, but I don't think that they have the final say either. I think the trial court has to make that finding.
I'm sorry, I'm a little bit confused there. So what would be the basis that the child there would be a finding of neglect if the child came home?
So I could imagine this exact case in the reverse, which is the hospital releases the child and the mother agrees, and then DHHS says, hang on a second, we know the hospital released it, but you can't possibly think that that's a safe situation. And the mother says, no, it's going to be fine. And then the DHHS files a petition and says, we actually disagree with you. We think that it would be neglectful to keep this child in that home given his threats against himself, against you, against his siblings, trying to burn down the house. Like, at some point, I think they could say you're turning a blind eye to the situation.
Okay. Thank you.
Thank you.
Good afternoon, Your Honors. Jennifer Rosen, Assistant Attorney General, appearing on behalf of DHHS. Seated at council table with me is Solicitor General Ann Sherman. The established statutory framework is designed to protect children, and it is the parent's responsibility to operate within that established framework to meet the needs of their children, regardless what those needs are, and ensure children's safety. DHS is certainly sympathetic to situations such as these facts, which certainly present extraordinary circumstances, but it's still essential for parents like Ms. Lange to operate within the established statutory framework. Section B1 in the jurisdictional statute allows for jurisdiction when a parent neglects or refuses to provide proper care or necessary support for a child, and Section B2 allows for jurisdiction when the home is unfit. These sections envision a spectrum of parents and don't necessarily require a finding of culpability. Consistent with this jurisdictional statute is DHS's mandate to keep children safe and families together when possible. It was St. John Hospital, as the court has recognized, not DHS, that determined DVL did not qualify for inpatient treatment. DHS then did its own assessment based upon the hospital's recommendation and secured intensive outpatient services in Lange's home, services she had not yet tried, but she would not operate within the established framework to help DVL. And I'm glad that the court asked about DVL's current living situation. He has not been in an inpatient hospital setting in the last over 3 years. He has been in 2 residential programs where he has been described as the poster child for placement. He is the model person while there. He has had some visitation with his mother, but the permanent plan now is not for him to return home because she has not agreed to have him home. Because despite his very good behavior for over the last 3 years, she has said that she still cannot have him home. And his permanent plan is now another permanent plan living arrangement working towards emancipation.
Okay, so Brother Counsel has stated that there's a lot of agreement between their position and DHHS's position.
Yes.
If you agree with some or all of that, can you outline where you think there's agreement?
Yes, there is a lot of agreement about the procedural history and how this case came about. However, DHS does not believe that this case lands squarely under B3 because DVL is not homeless. Simply put, his mom created his circumstances of homelessness. To expand the definition of homelessness to include perhaps mentally ill youth or youth with behavioral challenges such as DVL creates so many unintended consequences for the department and for the courts. Because even the Children's Law Section brief recognized that changing the statute is the job of the legislature, and that it's going to take a far more careful consideration and collaboration between all of the stakeholders, that being DHS, courts, community mental health, doctors, to come up with language that would both protect children and not allow the floodgates to open, allowing parents to drop their children off at DHS's doorstep and say, I can't handle this child, and it is too dangerous to have this child in my home.
But isn't that what the trial courts are for? I mean, isn't that what they balance they balance hard choices, right? And here we have a trial court who made findings that sound very different than the scenario you're painting.
However, when the court dismissed DHS's petition and said that Ms. Lange was essentially between a rock and a hard place with this young man, that still left him with nowhere to go because she still wasn't willing to take him home. That's why DHS filed the second petition, because he still didn't have anywhere to go.
Right, no, I understand the challenge. I mean, that part I understand. We're just trying to figure out if it should be called neglectful. I mean,
Well, like I said, Your Honor, parents have to meet their children where they are. And his needs are such that, she needed to provide him the assistance that he needed within the established framework.
But isn't that the role of the trial court in this contention? You say it's neglectful and seek jurisdiction under 1 and 2, and the trial court makes a finding of that. And I understand the position that you're taking, but that's not, the trial court did engage in that undertaking and found that wasn't the case, that she wasn't just saying, I'm dropping them at your doorstep, right? I understand the concern, and I think what I'm hearing is that that's the concern with finding jurisdiction broadly under sub 3, right? Because somebody
Yes.
could do that, right?
Correct.
But
Sure.
here in this case, the trial court did make that finding that this wasn't that circumstance, right? That this wasn't, and isn't that the role, whether it's, we're asking the trial court when you file a petition under 1 or 2 to make the finding that they were able to do so or weren't able to do so, or the home is unfit. That's the role that the trial court plays in this system, right?
Absolutely, Your Honor.
Okay.
But the question then becomes, well, what then happens to DVL and other young people like him? Because DHS couldn't service him without the court's intervention. DHS couldn't, where was he supposed to go if his mom wasn't willing to take him home, right, wrong, or otherwise? It's not a judgment about that. She wasn't willing to take him home, and he had nowhere to go. The best that DHS could do for him was to drop him off at a homeless shelter.
in which case he would be homeless then?
I guess at that point, he would be homeless.
So, okay,
But,
never mind.
but DHS doesn't want to create that circumstance either and wants to do better for children, especially one that
Well, are you
has
creating
the
that
needs-
circumstance if parent won't let him come home, and there's nothing that you can do if you don't have jurisdiction other than drop him off at a homeless shelter? I mean, who's creating that situation?
I'm sorry, you understand that one more time?
You said DHHS doesn't want to create the situation where they're putting a child in a homeless shelter, but are they creating it if a child is being discharged from a medical facility to the parent, and the parent is saying that the child can't come home?
Yes, I think that is creating a circumstance of homelessness, because then the child
Wouldn't
doesn't
that
have
then
anywhere to go.
be under one, when a parent is able to but refuses or is neglectful in providing care? I mean, like, I don't think that there's this gap that you're suggesting, right? Like, if you have the scenario where the hospital and everybody agrees and the trial court says, yeah, or maybe even before the trial court says that this child can come home, and it's a parent who is saying, no, I'm just not taking him home, wouldn't we be in the realm of sub one in that context, right?
Yes.
But on the other hand, if she says, I'm not taking him home, and the hospital says, well, you have to take him home, and the judge finds, and there's all this history of, there's reasons why he can't come home, and it's unsafe not only for him, but for others living in the home, why is that not sub three? The parent is not creating this, but it's a basis for jurisdiction, which I think everybody, right? I mean, the department wants to, obviously, you filed 2 petitions in this, like, you want to find jurisdiction over this child
Correct,
to get him services.
correct.
And I guess what I don't understand is the resistance to finding jurisdiction under 3. Maybe I get like as a sort of broad strokes or like in another case sort of thing. But here I'm struggling with why the department seems to be finding jurisdiction under sub 3 when their goal is to find jurisdiction over this child.
Because to paint such a broad stroke, Your Honor, would potentially open up the floodgates for other parents to do this exact thing.
But you
We
have
can't-
the backstop with the trial court. I mean, the trial court then steps in and says, no, you know, there's no reason, there's no safety issue at home, and either the child comes back home, or DHHS can take jurisdiction under P1.
Well, that's essentially what happened here, when the court said you can't.
No, I mean, the parent is saying it's not safe for him to come home. If everybody agrees, and the court agrees, it is safe for him to come home. There's no concern here. We're just trying to figure out why DHHS is so resistant to B3.
Well, I
We're
mean,
just trying to
that's-
find, and there may be other things that we're not considering, so.
Because DHS doesn't have the ability to, in general, provide services to a young person in a placement without the court's intervention. And it would be difficult to shoehorn young people like DVL into the homeless statute, or the homeless section of the dependency section, without, when there is the situation of, you know, a parent-created homelessness. You know, just as an example, that, you know, the dependency portion of the statute probably needs, you know, a look at from the legislature. I was actually involved in a conversation the other day about a young person who had a parent who is temporarily incapacitated. And we were discussing whether or not we could file under the dependency statute, because B3D says that a parent has to be permanently incapacitated or deceased. Well, that parent isn't permanently incapacitated. That parent hasn't done anything wrong by being in a catastrophic car accident, but don't have that designation of permanent incapacity.
What about
So-
Brother Counsel's suggestion, and maybe you can talk to this, that a finding of the court's jurisdiction is necessary or required for DHHS to provide services to this kid, to any kid, right? Like, I mean, and obviously, I don't think you would disagree that there are many sort of steps prior to a petition at which the
Absolutely.
department steps in and provides care and services.
And DHS asked Ms. Lange to participate in those services prior to the department filing its petition. Those services.
Outpatient, though.
Intensive outpatient services in her home. During the adjudication, Mom agreed that she had tried, that DVL had participated in outpatient services, and those were at a day treatment program. Like the day treatment program would pick him up in the morning and drop him back off in the afternoon. These services would have been intensive and in her home, with service providers in her home.
24 hours a day?
Probably not 24 hours a day, but there would have been service providers in her home. There would have been people watching all of the time, along with the oversight of the department. DHS would have kept its case open. Would that have completely avoided the necessity of having a petition filed ultimately? I don't know. But it certainly would have been a start to avoid the court's intervention, to avoid the court taking jurisdiction, to even see how those services worked.
Well, but she's also in this particular case, she's faced with 2 other children at home who are at risk of being harmed. She herself is at risk of being harmed. This latest incident is tried to set fire to the home, right? Like, I mean, there are you know, it's not in this vacuum, right? All of which
No.
was found by the trial court in finding that B1 and B2 were not met. I mean, it's all, I get the concern about a broad swath of saying that this could be abused or could lead to problems, but we're dealing with it in the facts of this particular case where the trial court found, in fact, that this wasn't somebody just trying to, you know, dump their kid off with the state, for lack of a better word.
Correct. That is correct. However, DHS could not, there was nothing that the department could do to help him without some sort of intervention, especially when Ms. Lange was not willing to accept those services in her home without court intervention.
What is your response to Brother Counsel's contention that if Ms. Lange had brought the child home and it wasn't safe for the child to be there, that DHHS would have stepped in and said that it was a neglectful situation?
I disagree with that. I see that happen all the time, or say that happen. I see situations like that happen all the time, and that is not what DHS does. They don't send a child home to a potentially dangerous situation, things explode, and then DHS comes in and says, all right, this is, terrible, and we're just going to remove children and file petitions. Absolutely not. They would have tried to put in different services. They would have tried to see if there were other places that perhaps DVL could have gone, if there were other places the other children could have gone, just to give everybody a respite. They would have come up with some plan to keep the family intact, keep the services in the home, and try to continue with that
And can they do that without jurisdiction of the child?
Yes.
They can.
Yes, because like counsel said, there are these 5 categories that protective services can disposition a case with, and they can, category 1 is a mandatory petition and a request for a removal, but anything, 2 through 5 is either,
Not a petition.
Not a petition. Services, whether those are in the community, monitored by the department, or something else. Well, if there are other questions?
Any other questions?
Thank you, Your
Thank you.
Honors.
Thank you both. The case will be submitted.